All right. Binger Boneheaded moment number 4. Hope you watched my last one. In Binger Boneheaded moment number 3, Thomas Clair Binger argued like crazy that he should have Kyle's address, his permanent address, and in so doing, he completely subverted his own argument, completely blew it up. Go back and watch it and laugh. At any rate, in Binger Boneheaded moment number 4, the judge is going to command Kyle to get his address. And it's not going to work out so well for Thomas Clair Binger, and he's not going to react well to it either. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
Okay, when we get done, we'll do a Binger score. Now, what does Binger stand for? Well, B stands for brainless, I stands for ignorant, and N stands for nasty. But let me set the stage here. This is towards the end of the hearing where Thomas Clair Binger tried to get Kyle thrown back in jail because Kyle didn't give him his address. And so the judge is now going to weigh in and tell the world his decision. Let's listen in.
And part of that, just a small part of it, is the risk that there would be the kind of concern that the defense has talked about in terms of the safety of the defendant.
That's right, the safety of the defendant. That was the defense's argument. And what did Thomas Binger do in Boneheaded moment number 3? Pretty much reinforce everything that the defense was saying. Yeah, it was that bad. But we move on.
And quite apart from the interest of the defendant, after what this town has been through in the last 6 months, I don't want any more problems. The police don't need any more problems. We don't need to have people's safety in jeopardy in any way. So I think that the desire that the bond or that the defendant's address be kept from public scrutiny is a legitimate one.
Oh, Thomas Binger is already thinking, darn it, I want that address out to all of my Antifa pretties. And he's not going to get it.
And what I'm going to order is that the actual physical location of the defendant, and it will be his place of abode. If he's going to remove from there, he'll have to follow the bond condition and give us the exact physical location of his place of abode.
Oh, look at Thomas Binger. Watch. Oh, he's nodding with his head. Yeah, he can't wait. He's got it. He said that Kyle Rittenhouse has to give us his address. All of my Antifa pretties out there will now know where he's living. Yes, this is working out beautifully.
And that is to be given to the deputy clerk working in this court, who will keep it privately. It will not be part of the public record. It's to be given to me. It'll be held the same way. And it's to be given to whomever the sheriff designates as the person who would be responsible for full knowledge of the whereabouts of the defendant.
And Thomas Clair Binger is now thinking, wait a minute. He didn't mention me.
And that is to be kept secret by the sheriff's office. So is that clear, Mr. Richards, what's required?
It is, Your Honor, and you and your clerk will have that by 5 o'clock today, and I will have it to the sheriff's department as soon as I'm told who to designate it to.
Does anybody see the steam rising from Thomas Clair Binger's head?
Okay.
Your Honor, I would also
Any
information be
Yeah.
shared with our office too, please.
Oh, Thomas Clair says, hey, what about us? Why can't we have Kyle's address? Can we, pretty please, have his address?
No.
No! Judge Bruce Schroeder says, no, hell no. Hell's no. Yet. Nine. And why? Because of Thomas Clair Binger's own strategy that we detailed in Binger Boneheaded Moment number 3.
The district attorney's office, and the answer is no.
Oh, now, here is how a seasoned attorney reacts to this news. He's going to put forth a good, reasonable reason. No, he's going to beg and snivel and whine. Watch.
That has nothing to do with you or your office. I think the sheriff would be your right arm, left arm, whichever is preferred, in discharging anything that would need to be done. And they're not to share it with you unless you offer good reason. And it's not that I don't trust you. I
It's because he doesn't trust him. Trust me.
think that the less
The fewer Nimrods that know Kyle's address, the better chance Kyle has of staying alive.
of this, the safer everybody is. As I said, you remember what went on 6 months ago here? I've got 2 broken windows here, right here in this courtroom. The doors are all still covered with plywood. A good share of the community is still boarded up after millions of dollars of damage, of property damage, and this ghastly event occurred. So no, I don't want anything that might kindle further violence. And so no, it's not a reflection in any way on you or your office.
All right, now, a real attorney would look at this and say, okay, he's made up his mind, and nothing I'm going to say right now is going to change his mind. I need a different strategy. Perhaps I'll write him a letter afterwards. But no, that's not what Thomas Clair Binger does.
Your Honor, I hope you're not suggesting that sharing this information with our office is somehow going to lead to further violence, because we would not be in any way contributing to that. But our obligation is to help monitor the defendant's bond conditions, and without knowing where he's at, that becomes very difficult. If I'm to file a charge of felony bail jumping, for example, for the defendant violating his bond, and I don't know where he's at, that makes it pretty difficult. And if the court has placed the
And you call the court,
and
call the court.
criticize me for not doing so in the past, then I feel like I need to have this information. And certainly no one on this Zoom call needs to be reminded of the events of 6 months ago. We have the loved ones of 2 deceased and a victim who was shot in the arm by the defendant that night. So
Please don't use the term victim.
Binger puts forth this really wonderful argument. He uses the word victim and allows the judge to derail him. I love it.
Mr. Grosskreutz was shot in the
Any
arm.
witness.
Your Honor, if Mr. Binger wants my client,
Now the judge is thinking, now wait a minute, there's another voice out there. Oh, it's Mark Richards. This actually might be sane and rational. I'll let him speak.
What's that?
if Mr. Binger wants my client to appear on what he's going to do next, which is issue a felony bail jumping, send it to my office. He'll be in court the next day. This posturing is not serving any purpose at this point. The court has ruled.
Your Honor, it's not posturing. This is standard procedure in all criminal cases that everybody knows where the defendant is. This
Standing operating procedure is not going to work in this court case. Obviously, this is a very unusual case, but oh well.
This is highly unusual for this to be withheld under seal. The court has ruled that it can be sealed from the public, but we are not the public. We are the prosecuting agency. We are the prosecutors on this case, and we have a very important right to know this information as the prosecuting agency in Kenosha County. And I have never heard of a situation where this information has been withheld from our office. The Sheriff's Department, you're right, is a law enforcement agency, but we work with them, and to withhold them from giving to us, the court not giving it from us, to cut us out of that information is not appropriate here. Our office is headed up by the elected DA, the chief law enforcement officer.
Well, are you going to give us the entire governing board organizational chart here?
in this community. This is a murder case, and we are entitled to this information, Your Honor.
Oh, you're entitled to that information. Oh, strong words.
We have never been denied this information in any case that I've ever heard of. And
well, now you have been.
If the court is aware of a case in its history where you've not shared this information with us, I would appreciate you sharing that with us, letting me know what case that was.
Okay, that's almost borderline contempt of court. Shut the hell up.
Because this is highly irregular. We have a right to know this. I would argue
a right to know it. Oh, wow. What is the legal meaning of the word right? And does it match what he is saying? No.
The public has a right to know it as well. I understand the court's ruling from sealing it from the public, but
well, then the public doesn't have a right to know it if you could conceal it from them.
But our office has a responsibility to enforce the laws, enforce the bond here, to file bail jumping charges if there's a violation of that, and we cannot do our job without this information.
If the sheriff can keep on top of this as to whether there's a violation, that's where most of your information, when I was district attorney, and I know it's been a long time.
Okay, whenever the judge starts off with, when I was a district attorney, you've lost the argument.
But I didn't have any investigative staff except one investigator, which I won't go into. But the sheriff's department was in charge of reporting bond violations and the like to us, and I think the same situation is true now. Hearing's over. Thank you.
Oh, the hearing's over. Thank you. When the judge says that, there's no point in continuing on. He's not all of a sudden going to say, oh, wait a minute, that's a good argument. Let me rethink this. Not going to happen. Oh, wait, I just got a message here that my Binger boneheaded moment is not fair to the hearing impaired. So I'm going to bring in a little bit of sign language interpretation for the rest of this video. So, okay. So here I am, a sign language interpreter for those of you who a little bit of hard of hearing.
The
defendant doesn't reside in Kenosha County, Your Honor. The sheriff can't help me because he doesn't reside.
Thank you.
Have a good afternoon.
Good afternoon.
Okay, so how about a Binger score? What about brainless? In terms of brainless, I give this one a 2 out of 5. It's not the worst that he's ever done. But any kind of seasoned lawyer should have recognized the fact that the judge had turned against him. Going on and begging like a little bitch is only going to piss off the judge even more. You have to be able to size up the room a little better than that. So it was rather dumb for Thomas Binger to continue to try to beg and plead for Kyle's address when it was clear that the judge had no intention of giving it to him. The judge isn't going to all of a sudden change his mind and say, oh, wait, you know what? Maybe I should go ahead and give it to you after all. This would have been a perfect time to back away from this thing, maybe write a letter to the judge, try some other tactic. But going there in front of everybody and crying like a little bitch for his address was really a bad move. That was dumb, but it gets a 2 out of 5. What about ignorance? Frankly, it would have been 0 out of 5 until he started talking about entitlement and rights and all that. He clearly showed that he doesn't understand the public's right to know. And there's no entitlement there. He is not entitled to have Kyle's address. So I give that one a 2 out of 5. What about nasty? It's a 5 out of 5. Let's face it, he wants Kyle's address for a reason. And it's not so that he can just keep an eye on Kyle so that he can monitor him for bail jumping. Within short order of him getting Kyle's address, you would have seen vandalism, protests, everything going on outside of Kyle's house. Somebody would have been BCC'd his address by mistake, of course, but he would have got it to all his little Antifa minions somehow. Now you may be thinking, well now, why can you say that? It could be very innocent reasons. Listen to him beg and whine and plead. He wants his address bad. So this wasn't about just keeping an eye on Kyle. This is a lot more to it than that. So he gets a 5. for an overall Binger score of 9. Like my video, subscribe to my channel.